Bill Twyford.
I want to thank the Minister for livening up our afternoon with that contribution. It won't quickly be forgotten. We're supporting this bill, Mr Speaker. There's nothing wrong with a bit of repair and maintenance work from time to time, but I do have to ask why we are considering changes to the Unit Titles Act now, sir, when it's been well known that there are major reforms overdue of the Unit Titles Act, and I want to speak a little bit more about that later, but it's a shame that we're spending the time of the House on a set of, inconsequential would be too harsh, but very minor tweaking of the Unit Titles Act when there is such broad structural reform is needed in the sector. I also want to question whether or not with the Building Act, for example, why wasn't that included in, for instance, a statutes amendment bill? I would have thought that could have been easily dealt with in that vehicle. With the Unit Titles Act, another possibility would have been, for example, the recent changes that we saw on the omnibus bill on affordable housing. And I raised the question, in fact, why that bill was pushed through the House under urgency, completely unnecessarily. It extended the special housing area legislation and made changes to the provisions in the Public Works Act about the future repurposing of land that had been, for housing purposes, that had been acquired under the Public Works Act. Why that was pushed through the House under urgency without select committee consideration, when it could easily have been incorporated in an omnibus bill such as this one. But never mind that, we are debating this right now, and I want to just focus some comments around the provisions in the Unit Titles Act. What the bill sets out to do, according to the commentary, is that it wants to clarify and update the Unit Titles Act, addressing various inconsistencies between the Act and other legislation, updating the regulatory system in the Unit Titles Act, and trying to reduce unnecessary compliance costs. On the face of it, that sounds fine, sir, and we'll be at Select Committee scrutinising the bill and testing the provision, the detail and the provisions of the bill against those claims. Specifically, it allows a principal unit to comprise more than one car park. It puts in place a simpler process for subdividing a principal unit, expands the ability of an owner to deal with their unit by giving them the right, with the body corporate's consent, to grant an easement over their unit. So there's a number of things that are designed to try to ease the way for owners in multi-title dwellings to kind of get on and manage their affairs with the body corporate. This sector is incredibly important. It's the residential apartment sector is estimated to be worth about $40 billion. There's no question that in our country's biggest city, that apartments are going to be a more and more significant part of the urban fabric, and we're seeing a significant number of apartments being built, and one hopes with the passing of the Auckland Unitary Plan, which will allow much more upzoning, much more density, that we're going to see more and more apartments. And anyone who lives in an apartment or kind of works in this sector will tell you that there are serious problems with the legislation as it stands right now. There is an overdue need to put in place protections and accountability requirements to do with the body corporate managers. Better disclosure rules are needed so that very early in the purchase process, people have all of the relevant information they need about a unit or an apartment or the governing body corporate. We need better dispute resolution processes in place. And it goes on. And I know that the government has done some work on this, and I want to acknowledge the work that the Honourable Nikki Kay has done, bringing this to the attention of the government. Nick Smith has said that he's looking at the recommendations from the unit titles working group that was set up with a number of significant players, consumer advocates, lawyers, apartment owners, that I think did some pretty solid work looking at the whole reform agenda that's needed for the Unit Titles Act. And one of the other concerns is about abuses of power really within body corporates, the whole practice of proxy farming, where a single individual manages to marshal a whole lot of proxy votes and essentially dominate the decision-making process for their own purposes. And one of the other concerns that I've had raised with me on a number of times is the lack of rules and requirements about the funding of long-term maintenance plans. And I know some people have proposed that there be requirements in place that would require not only long-term maintenance plans to be in place, but to be properly funded. And there needs to be an accountability mechanism so that if those plans aren't up to scratch, if they aren't properly funded, then there needs to be some kind of body that, that members of the body corporate can go to for appeal purposes. Without that, you get the kind of situation where we're seeing more and more with body corporates, and that's people find themselves faced with massive repairs and maintenance costs that in some cases are seeing people forced to sell their title, and we've seen people in their retirement years facing financial ruin because of this. So I hope that we'll see, notwithstanding this minor piece of repair and maintenance to the Unit Titles Act, I'm hoping that we're going to see from the government something far more substantial in this area before very long. The other matter that I want to comment on is to do with the Construction Contracts Act, and I'm glad that my colleague Clayton Cosgrove is in the House because he knows a lot about this area, and I'm sure he'll have something to say about the provisions in the bill, the Regulatory Systems Building and Housing Amendment Bill. Now, what we can see in the back of this bill is that it basically corrects a drafting error. Mr. Speaker, in the bill that Nick Smith, Minister of Building and Housing, brought to this House. I'm pretty sure it was passed probably earlier this year. And what this does is essentially it clarifies that as of 31st of March 2017, that the requirement for retention money to be held in trust, that kicks in as of 31st of March 2017. It does not apply to contracts that were in place prior to and at the time of this provision becoming operative. And that lack of clarity in the legislation has caused a great deal of concern and confusion in the industry. All of those people who, all of those jobs that are underway prior to March 31st, 2017, face the prospect of their contracts being made much more complicated as a result of that drafting error. So what this bill does is that I think it'll be very welcome for parties in the construction industry who have been expressing concern about this. But that it is worth, I think, noting that the requirement for retention monies to be held in trust was a really important reform that people throughout the construction industry welcomed, and I think it was supported by all parties in this House. So, sir, we'll be supporting this bill to Select Committee. Other colleagues are going to comment on all of the other elements, the workplace relations elements of this bill, but we look forward to scrutinising the detail of these provisions at Select Committee. Thank you.